Good afternoon. Thank you all for joining us today. My name is Juch Nam, Executive Director of AMCHAM Korea. Welcome to our 40th webinar on recent amendments to the Monopoly Regulation and Fair Trade Act, also known as MRFTA, by Bae, Kim, and Lee LLC. Bae, Kim, and Lee's competition and antitrust attorneys will discuss one of the most sweeping changes in the MRFTA's 40-year history since its enactment in 1981. They will focus on the new amendments, how they would impact information exchanges among competitors and cartel enforcement, and the role of criminal penalties in regulation of competition laws, as well as civil and equitable remedies for antitrust violations, including the introduction of preliminary injunctions. Sanghoon Shin is a senior foreign attorney at Bae, Kim, and Lee, specializing in various antitrust and consumer protection cases. Mr. Shin passed the 40th civil service exam in 1996 and earned his JD from George Washington University Law School in 2004. Keewon Shin, another senior foreign attorney at Bae, Kim, and Lee, has over 20 years of experience in corporate legal affairs, capital market, and fair trade. Having passed the New York Bar in 2002, Mr. Shin graduated from Yale University and earned his JD from Columbia Law School. Lastly, Hyuna Kim is a partner at Bae, Kim, and Lee, and her practices include business combination, cartel, abuse of dominant market position, and unfair transaction. Currently a member of IBA Antitrust Committee, a cartel working group, she is well known for her being awarded the recommended lawyer in antitrust and competition by the Legal 500. Given the Korea Fair Trade Commission's active enforcement history, we hope this webinar would serve as a great opportunity for your business in Korea to better understand some major changes in the MRFTA and be on the right path when considering appropriate compliance measures. Should you have any questions, please be sure to address them only during the Q&A session at the end and not on the chat function. Thank you.
My name is Keewon Shin. I'm a senior foreign attorney in the competition group of Bae, Kim, and Lee, and presenting with me as introduced is Hyuna Kim and Keewon Shin. It's our very great pleasure to be presenting this webinar in collaboration with the American Chamber of Commerce, who I want to thank for bringing this event together. Just a bit of brief introduction of our firm and our practice, if you don't already know. Bae, Kim, and Lee was established in 1980 and is now one of the top full-service law firms in Korea with more than 650 professionals, including 530 attorneys and 120 other professionals located in 10 offices worldwide as of 2020. And our competition group is comprised of approximately 60 attorneys and 10 special advisors, offering what we strongly believe is unmatched excellence across the full spectrum of antitrust matters, ranging from international cartel investigations, merger control, antitrust compliance, as well as administrative, civil, and criminal litigations. Additionally, we work very closely with our forensics team and provide clients with cutting-edge expertise in identifying potential risk areas and by providing preventative solutions using forensic technology. We are widely recognized for our capabilities by various industry publications, including ranking as a tier 1 law firm for antitrust and compliance by Legal 500. We also expanded our ability to provide economic analysis in complex merger and litigation matters by the recent establishment of our Center for Law and Economics and bringing Dr. Richard Shin as its head with experience at the US DOJ as well as the Fair Trade Commission. With this team's combination of extensive private and public sector experience, we believe that our Center for Law and Economics will be an invaluable resource in effectively advising clients. We also want to highlight BKL's top-tier criminal defense services with 28 attorneys, formerly from the prosecutor's office, 8 attorneys, and 1 special advisor from the police. And in light of the increasing utilization of criminal enforcement as a tool by the Korean government, as well as the expanding investigation power of the police, and we will be discussing this point a little bit later on this webinar, we've added 4 attorneys from the police and 2 attorneys from the prosecutor's office just within the past year. And hopefully this lets you know a little bit more about our firm and our practice. A bit more detail about the session today. As mentioned, today's presentation will be focusing on the major changes expected from the recent amendments to the Monopoly Regulation and Fair Trade Act, which is the Korea's primary antitrust statute. And those of you who follow the trends in Korean antitrust laws may already know these were finally passed by the National Assembly in December last year after many months of public debate and revisions, and it's the most sweeping set of changes in 40 years history of the MRFTA. And as you also know, KFTC is actually one of the most active enforcement agencies when it comes to competition and fair trade matters. And we wanted to use this opportunity to highlight some of what we believe are more important changes that are expected from these amendments, and also share some thoughts on how you can begin preparing for such changes. We'll start off by discussing changes on how information exchange among competitors in the market will be regulated, and the scope of information that will be regulated. Our executive session will cover developments of enforcement and the direction of how criminal penalties will be used to regulate competition laws. And this was actually one of the most hotly debated topics on these amendments, including on the issue of jurisdictional authority over criminal enforcement for antitrust statute violations, whether it be the KFTC or the prosecutor's office, including who has the right to grant leniency. We'll then finally move on to discussion of procedure improvements, in particular with respect to private enforcement and the right of defense. And while we don't believe today's webinar will be covering all the changes, including the recent amendments or every implication of such changes, we hope that it will at least give you some broader understanding, as well as putting you on the right path to thinking about how your business should be operated in Korea. After the sessions are over, we'll have a short Q&A session, and the questions for which we cannot answer at the Q&A session due to time constraints, the presenters will be happy to send email responses. Thank you all again for joining today's webinar, and we hope you find it helpful. So I'll be presenting the first session on the regulation of information exchanges under the MRFTA. And I'd like to begin by first discussing how the current MRFTA regulates exchange of information on slide page 2. And then I'll explain the details of the new amendments, what has been changed in these amendments on pages 3 and 4. Then close off by talking a bit about what the changes would actually mean for businesses. I guess we're having a little bit difficulty listening. Just bring this over closer to me. Okay. Okay, so under the current MRFTA, simply the act of information exchange among competitors does not constitute a type of cartel conduct. And the presumption of cartel conduct cannot be made solely based on the exchange of information. And this is probably based on the fact that the authorities recognize that certain exchange of information is helpful and is inevitable among competitors in the market. The Supreme Court of Korea, ruling on several previous cartel cases, found that the mere agreement to exchange information alone does not constitute cartel conduct, and this was in the case of famous cases involving ramen companies or life insurance companies. And in light of such Supreme Court precedents, the KFTC recognizes an implicit cartel conduct, and obviously there are situations where the KFTC is unable to identify any explicit agreement to collude, such as memorandum stating or email stating that, well, let's agree on a price or let's agree on a market altering agreement. But if there are additional circumstances, such as external conformity of behavior, then the KFTC finds that there is an implicit cartel. For example, if there are changes in prices either simultaneously or in close proximity to the information exchange, then such price changes would constitute that additional external conformity of behavior necessary to find an implicit cartel conduct. So that was a standard in the current MRFTA on how they viewed information exchanges. And when the MRFTA was amended in last December, there were 2 new provisions related to information exchange, among many other changes that were added. The first is the amended MRFTA inserting an agreement to exchange of information as a type, specifically as a type of cartel conduct. And I have listed on this slide Article 40, Paragraph 1 of the new MRFTA on the slide. And as you can see, there are several types of unfair cartel conduct listed, such as price fixing, output restriction, number 8 being bid rigging. These are all very standard ones. And as the new section number 9, they've included an act that substantially restrains competition in a certain transaction area by exchanging prices, output, and other information. And this is a new provision, now which has been now included as a type of cartel conduct. And as I mentioned before, previously, a mere agreement to exchange information alone did not constitute a cartel conduct under the existing MRFTA. But with this new provision, it has been now included as a specific type. And this is significant because unlike the US, Korea is a civil law jurisdiction and requires there be a specific provision in law regulating the type of conduct for the authority to enforce it. And now they've clearly included information exchange as a type of prevented cartel conduct. And talking about the second change regarding the information exchange, I've included here in this slide, Article 40, paragraph 5. And what this adds is a information exchange being an event that gives rise to the presumption of an agreement. And reads, where the enterprises have exchanged information necessary for the cartel conduct of the paragraph 1, and that's the paragraph that I just listed in the previous slide that lists out the conducts, then the enterprises shall be presumed to agree that they would jointly engage in cartel conduct. So prior to the amendment, there needed to be additional circumstances such as external conformity of behavior. It's necessary to establish there being a presumption or there being a cartel conduct. But under this new amended MRFTA, the exchange of price information itself may be presumed as price fixing. And what this does is it shifts the burden of proof from the KFTC to the companies in having to show that their exchange of information did not result in anti-competitive effects. In talking about how these terms will actually be interpreted by the courts, as I mentioned, under the existing MRFTA, the courts have taken a very conservative position towards information exchange and requested that KFTC provide evidence of price fixing information explaining that information exchange alone is not a sufficient ground for cartel violation. And to be fair, even with these changes, it's still very uncertain whether the court's position will change significantly because of these new provisions. So our view at this time is that it's still very likely that the KFTC will just use these new provisions as added tool and overlay these provisions, apply one to supplement the other to increase the possibility of finding a cartel conduct. For example, the KFTC will try to establish their case. There'll be various evidence that are direct, indirect, on, let's say, for example, price fixing claim, to prevent the risk that their decision or their findings may be overturned because of insufficient evidence that they presented. They may try to supplement their price fixing charges by adding on these violation based on information exchange, just as an added enforcement tool. Just to provide a bit of comparative background, the EU, they have been already regulating information exchanges among competitors as what's called a concerted practice, which is a looser form of coordination that does not exactly require a binding agreement, but does require there be a consultation, subsequent conduct in the market, and a causal relationship between the two. And consultation is defined as a form of coordination where competitors knowingly reduce competition through their actions. So it's a bit looser than a direct cartel. And these could include all forms of information exchanges, horizontal and vertical. Horizontal information exchanges can also occur through third parties, such as trade associations or market consulting companies. And they generally carry a very high risk of restricting competition than vertical exchanges. But even for the EU, there's really no hard and fast list of permitted or prohibited information exchanges, and assessments are generally made on a case-by-case basis. But the general consensus that more strategic the data, more likely it is that EU will find it in restricted competition, and this includes information on price, quantity, or capacity, which are more always closely scrutinized and raises more risk that the Commission will find it anti-competitive. The EU also Commission has also set out a separate guideline on the application of these rules to horizontal cooperation. Again, the test is generally being the rule of reason approach. What was the reasoning? What was the information exchange? What impact did it really have on the market? For the US, across the continent, DOJ through its antitrust guidelines agrees that exchange or disclosure of competitively sensitive information can lead to certain collaboration among competitors. But it also does recognize that sharing certain information is necessary and also does have certain pro-competitive effects, including sharing technology, know-how, other essential IP that could ultimately lead to consumer benefits. However, again, the US, for information more competitively sensitive, such as price, output costs, strategic planning, it raises concerns that this information sharing could lead to collusion. And sharing of current or future business plans is more likely to raise the concern here. Again, similar to the EU, the US approach is a rule of reason approach or balancing to see the pro-competitive effects of the information sharing against any anti-competitive effects, and will take into account various circumstances involved in the information exchange. This obviously doesn't include any information sharing with the goal of colluding in the market, including any price or output. where there's an explicit goal that can be proven, obviously there's no exemption. So ultimately, similar to the US and EU, in Korea, it's going to be a very fact-specific analysis on what information exchange will be penalized as a prohibited conduct. And it will strongly depend on the type of information that's exchanged. So if the information exchanged is confidential and can possibly affect competition, then yes, the exchange of information alone now could establish cartel conduct in Korea. On the other hand, if the exchange of information is public information, such as statistics or past price information that's already disclosed, then it's less likely to establish cartel conduct. So after all this, and it basically tells you that exchange of information will now be looked at closely, and it will be that causes additional burden on the company to show that discussion of information with the competitors did not result in inclusive conduct. What it means is that first, it is critical for the companies to closely manage all incoming and outgoing information. For instance, any sharing of sensitive information, such as price increase plan through fax, emails, or meetings, should be strictly prohibited. And also, if any information of a competitor was lawfully obtained, it would be important to specify the sources of information when you maintain that information in your systems. We have really seen many instances, especially for companies with compliance officers located overseas, with the head office not being clearly aware of the information that the salespersons on the ground in Korea exchange at client meetings or personal connections, and has led to legal issues in Korea, with it sometimes leading into cartel behavior. So it is highly recommended to introduce an internal information management system to ensure that anti-competitive information is not shared with competitors, and to use them as evidence in supporting the company should there be an issue later down the line, or inquiries are raised by the KFTC. And obviously, to conduct regular training on these rules and the importance of minimizing contact with competitors, especially regarding any matters that are directly competition related. So it does appear, based on this, that there should be just more careful eyes over exchange information with other competitors. And again, these may happen at working level very casually without awareness that it could be a problem. So our recommendation to the business operating Korea is that you take a look at what your current information management system is and think about ways in which you could ensure that these informations are managed properly. I hope you found this first session informative, and we'll now move on to the second session by Hyuna.
Okay, thank you, Keewon. I'm Hyuna Kim, an antitrust partner at BKL. For the second session, I'd like to start with a brief explanation about the changes in cartel-related provisions under the amended MRFTA. Under the amended MRFTA, which will become effective as of December 30th this year, the upper limit of the surcharge applicable to cartels has doubled. The upper limit of the surcharge for abuse of market dominance and unfair trade practices has actually doubled as well. Currently, the maximum surcharge for cartel is 10% of the relevant revenue, or 2 billion Korean won, if the relevant revenue is impossible to calculate. Under the amended MRFTA, the maximum surcharge will be 20% of the relevant revenue, or a fixed amount of 4 billion Korean won. The KFTC will be preparing the amendments to the related enforcement decrees and its guidelines on calculating the surcharge amount within this year, and the actual surcharge amount will increase substantially. It should be noted that the increased surcharge will apply to any cartel conduct that ends after the effective date of the amended MRFTA, even if such act commenced well before the effective date. In many cartel cases, the KFTC has recognized agreements that continued over a long period of time as one single cartel conduct. For example, if an agreement among competitors which began 5 years ago is punished as one single cartel conduct next year, then the surcharge amount will be calculated based on the relevant revenue generated within the whole 5-year period, applying the surcharge rate under the amended MRFTA. Cartel is criminally punishable in Korea, like in many other jurisdictions. What is unique in Korea is that, in principle, criminal proceedings for violations of the competition law do not commence unless the KFTC first renders its decision on whether to issue a criminal referral. There have been several attempts to revoke the KFTC's exclusive right of referral for hardcore cartels, and in 2018, an amendment bill was proposed by the KFTC in this regard, but it was not passed by the National Assembly at that time. The original version of the amendment bill that was passed by the National Assembly last year it also included a provision to revoke the KFTC's exclusive referral authority for the hardcore cartel, but the ruling party decided to exclude such provision at the very last moment. So the KFTC's exclusive criminal referral authority remains unchanged. There are some exceptions. The Prosecutor General and the head of these three government agencies may request the KFTC to issue a criminal referral. For any case, the KFTC decides not to issue a criminal referral, including leniency cases, if they deem there has been an objectively clear and material violation of the MRFTA. The KFTC is obligated to issue a criminal referral upon receiving such a request. There are only few precedents where the Prosecutor General requested the KFTC to issue a criminal referral. For example, in 2015, for the first time in history, the Prosecutor General requested to issue a criminal referral against a construction company in a large-scale construction bid rigging case. On the contrary, the requests from the Administrator of the Public Procurement Service and the Minister of SMEs and Startups have been gradually increasing, particularly for bid riggings related to public procurement or cartels involving large companies in order to protect SMEs. However, I'm not aware of any precedents where a request was made to issue a criminal referral against a foreign company or individuals. So far, most of the individuals involved in cartel have been sentenced to probation or ordered to pay a fine. However, there were exceptions, and in some high-profile cartel cases, Korean officers of Korean companies were sentenced to imprisonment for their involvement in cartel conduct. As for foreign individuals and companies, there are a few cases where the court imposed fines against officers, but there has not yet been a case where prison sentences were imposed on non-Korean C-level employees. In many past international cartel cases, the KFTC investigation period passed beyond the statute of limitations of 3 years, so the KFTC could not make criminal referral in the first place. However, the amendment to the Criminal Procedure Act in 2007 stretched the statute of limitation to 5 years, giving more room for the KFTC. Recently, the KFTC has been making criminal referrals for all hardcore cartel cases and focusing on cases for which the time is running out. Given this trend, the KFTC is likely to issue criminal referrals more and more actively in the future. Unlike other types of cartels, when your company is involved in bid rigging, you may need to be prepared for the police investigation in addition to the KFTC investigation starting this year. This could be a bit complicated, so let me walk you through step by step. Firstly, you need to understand that bid rigging constitutes not only cartel conduct under the MRFTA, but also an obstruction of bid under the Criminal Code or the Construction Industry Act. The difference between the Criminal Code and the Construction Industry Act is that the latter is a special law applicable to construction companies with heavier punishment. Moreover, only individuals are punishable under the Criminal Code, but under the Construction Industry Act, companies are also punishable together with individuals, which is the case under the MRFTA as well. Bid riggings in violation of non-competition laws are not subject to KFTC's exclusive criminal referral authority, and an independent criminal investigation may be initiated by other competent authorities. For instance, in 2019, the prosecutor's office independently investigated investigated without any referral from the KFTC. The bid rigging by some Korean pharmaceutical companies for vaccines procured for the government based on the charge of a criminal code violation. Secondly, you should also note that additional changes have been made in the authority to conduct criminal investigations. The Korea Prosecution Service, or KPS, used to have investigation power for any crimes, but starting this year, the investigation power for most crimes were transferred to the police. As a result, the KPS now only has the investigation power over some very limited material crimes, such as white-collar crimes, although violation of the MRFTA remains subject to KPS's investigation. Therefore, the police may initiate investigations on bid rigging without the KFTC's criminal referral when the charge is based on the violation of the either criminal code or the Construction Industry Act. At the same time, the KFTC may also commence its own investigation and decide to make a criminal referral to the KPS for violation of the MRFTA. Upon the KFTC's referral, KPS will start the criminal investigation and decide whether to indict. As an in-house counsel, one thing I want you to remember is this. When your company is involved in bid rigging in Korea, you need to be more cautious and well prepared from the very early stage of the investigation. Starting this year, some changes are also expected in relation to the leniency program. Last December, the KPS announced that it launched its own leniency program in addition to the KFTC's existing one. This announcement was made before the amendment of the MRFTA, based on the expectation that the KFTC's exclusive right will be revoked by the amendment. As I explained just before, things changed dramatically at the very last minute, and the KFTC still has the exclusive referral right. Therefore, the leniency program of the KPS will likely apply mainly to bid riggings in violation of the non-competition laws, and it is very unclear whether the KPS leniency guidelines would apply to hardcore cartels in violation of the MRFTA. There are several differences between the two leniency programs. The most important difference would be the benefit granted to the second-ranking applicant. While the KFTC grants full immunity from criminal punishment to the second-ranking applicant, as well as the first-ranking applicant, the prosecutor may only offer a 50% reduction in criminal penalties for the second-ranking applicant when he or she recommends the degree of punishment at the court. Then this does not guarantee anything because it is the court that makes the final decision. Another difference worth noting is that an individual may independently apply for leniency and get immunity from criminal punishment under the KPS leniency program. According to KPS's leniency guidelines, if an individual turns himself or herself in during the investigation, a compulsory investigation such as arrest or search and seizure will be limited, so there are benefits for an individual to apply for the KPS leniency program. This means an individual such as a retired employee or a whistleblower may independently apply for leniency without giving any notice to the company. Such individuals filing for leniency would make it much harder for the company to supply the relevant materials and evidence of its participation in rigging to the KFTC or the KPS when it files for leniency. This would in turn lower the company's chances at immunity from criminal punishment through leniency. Thus, the companies need to pay more attention to managing and taking care of their employees, including their retired employees. Although the KPS now has its own leniency program, it is still recommended to file for leniency with the KFTC on cartel matters. Theoretically, of course, with respect to bid riggings, the KPS can proceed with prosecution upon the police's investigation without having to wait for the KFTC's investigation and criminal referral thereafter. So it would be safer to apply for leniency with both agencies. However, the likelihood is somewhat low for the police to commence its own investigation independent of the KFTC's investigation, unless it is a high-profile bid rigging case. So filing for leniency with the KFTC alone may still be preferred. For your information, last Friday, KFTC published the draft amendments to its leniency guidelines, mainly relating to the qualification for the second ranking leniency applicant and the requirements for the Amnesty Plus, among others. If you are interested, you may submit your opinion on this draft by May 6th. Antitrust compliance is becoming more and more crucial for any company doing business in Korea. Once the amended MRFTA comes into effect next year, it is expected that the surcharge amount for antitrust violations will dramatically increase, as we've discussed. And as Sanghoon will explain in detail in the next session, private enforcement will also become more active. Therefore, it is advisable to carry out a more comprehensive inspection of internal compliance within this year before the amendment MRFTA is enforced. Thank you for listening.
Thank you, Hyuna. Hi, everyone. This is Sanghoon Shin, and I'll be presenting in this third session the procedural improvements intended in this revised MRFTA. I'll be focusing on the improvements in the private enforcement activities and the procedural fairness in terms of right of defense. So first improvement is the introduction of injunctive relief. So currently, there may be some parties who suffered from antitrust violation. And for those sufferers, they may have options to report the violation to the KFTC for administrative investigation by the KFTC. And a private enforcement available for them currently is only to file a lawsuit for damages. But as we don't have any discovery system, just like the US system, it is very hard for the plaintiff to prove the violation by the perpetrator. So practically, it is a widespread practice for the company, for the sufferers to report the matter to the KFTC first and wait until the KFTC completes its investigation and finds a violation by the perpetrator. And then these sufferers will make a lawsuit, damage lawsuit to the court, citing the KFTC's investigation as a proof of a violation. But this has a clear limitation in that these sufferers can resort to the court's rescue only after the harm is done on the company, and only the compensation can be made only through the monetary compensation. So realizing this kind of limitations under the current MRFTA, the revised MRFTA introduced the injunctive relief system. So under this new system, the private parties, to prevent a antitrust harm from taking place in advance, the plaintiff, the private parties can directly seek injunctive relief from the court. By this injunctive relief, they can seek for the court to enjoin a conduct in violation of antitrust law. So what kind of conducts will be subject to this court's injunction? This closely is related to the situation where this kind of a court injunction can be most useful. That situation is the violation type of a unfair trade practices, among others. So under the current proposed current revision, the conduct subject to the court injunction is the type of violation which is unfair trade practices, such as refusal to deal, imposing unfair disadvantageous terms or forced sales targets, things like that. And who can apply for this court injunction? The private parties actually harmed by the unfair trade practices, or potential victims who are threatened to sustain damages from unfair trade practices. So the biggest implication for the court injunction is that this is available before the KFTC's investigation or decision. So what are the implications of the revision? There may be small and medium-sized companies who are in inferior position in negotiation with larger company or in dealing with larger companies which has superior bargaining power over these SMEs. And they may be sometimes put in a disadvantageous situation because of the kind of coercion by this larger companies. So currently the meaningful recourse for these SMEs are definitely reporting the matter to the KFTC for investigation. But now from next year, they also have another option to bring a injunction case in court. So they may have used this option, this additional option, as a leverage in negotiating with the larger companies. There are another private enforcement option which are under discussion in the National Assembly in Korea. So this is in the context of the revision, a proposed revision of Korean Commercial Code, not the MRFTA. And under this proposed revision of Commercial Code, there is new system of class action, opt-out type of class action, doubled with the 5 times punitive damages for violation of Commercial Code, and this violation includes the antitrust violation as well. So if this amended Commercial Code will be passed by the National Assembly, then it will have the explosive effect on provoking the private enforcement for damages as well. Another procedural improvement is the production of evidence. This is in terms of the right of defense for the investigated companies. The background is something like this. There may be a third party who are interested in antitrust investigation by the KFTC, and this third party can assist the KFTC's investigation. There may be, for example, there may be a unfair trade practice investigation by the KFTC, and this third party may be the company who reported the matter to the KFTC. And to assist the KFTC, they may provide a meaningful evidence material for KFTC to review and to invoke in their decision. But the KFTC often does not disclose these important documents to the investigated companies because this document may include the business secret of the party who provided this information. And also, production of this document to the investigated company will disclose who provided this information and may lead to the possibility of retaliation by the investigated company. But from the perspective of the investigated company, it hugely hinders the right of defense because they cannot have access to important evidence material invoked by the KFTC. In the past, mostly the investigated companies gave up appealing the KFTC's decision not to disclose. But recently, a few years ago, WeKL was the first law firm who argued this issue in court. So we filed a lawsuit against the KFTC to compel the production of evidence material. which was not disclosed by the KFTC. In this lawsuit, even though we ultimately lost the lawsuit itself, but during the course of the lawsuit, we succeeded in obtaining most of the requested information and documents from the KFTC. So the purpose of the lawsuit was successfully achieved. But anyway, the KFTC recognized that there are a lot of criticism about the hindering of right of defense in this situation. So the KFTC recently introduced a new guidelines on limited perusal of evidence documents. So under these guidelines, the investigated companies can request for production of undisclosed evidence documents. Then the KFTC asks the third party who provides this information whether it consents to the disclosure or not. And if the third party consents, then the KFTC will produce the documents to the investigated company. And if the third party does not consent, then the KFTC will allow so-called limited perusal. And what is this limited perusal? The KFTC takes pride in that it will operate as a Korean-style data room. And what does that mean? Is that there is a actual data room established in the KFTC's premise in Sejong City, and the investigated company's external counsel can visit the KFTC's data room and review the undisclosed evidence documents in the data room. And they can make some notes, but they cannot make copies, or they cannot take that evidence documents out of the data room. So there is a strict confidentiality obligation, and if the external counsel violates this confidentiality obligation, they will be sanctioned by the Korean Bar Association. And also, but if the requested documents are part of unconsented leniency application material or undisclosed pursuant to other laws, this limited perusal cannot be available. So there is a limitation. What are implications of this limited perusal system? Definitely, it is a huge improvement in terms of the right of defense by the investigated companies. But as I said before, even though it is an improvement, there is still a lot to improve more. So we will have to wait how the KFTC will operate this system in the future. Another aspect of procedural fairness is in terms of the civil damages suits. And in these civil damages, where the private party who suffered from antitrust violation seeks document production from the defendant who violated the antitrust laws. As I said before, there's no discovery procedure in Korea in civil damages suits. So even if the court orders the defendant to produce the documents requested by the plaintiff, the defendant can refuse to comply with the order on the basis that such document has trade secrets, and there is no penalty for that refusal. But under the new MRFTA, in civil damages suits, if this requested document is important to prove damages amount by the plaintiff, then the court may issue an order for submission to the defendant, and the defendant should comply with the order. And if the defendant does not comply with the order, then the intended aspect of argument to be proven by this requested document will be presumed to be proven. And the defendant is not allowed to refuse the order without legitimate grounds, and the trade secret is not a legitimate ground for refusal. Okay, so what is the implication? So this is also another procedural fairness issue to balance between the plaintiff and the defendant, and the plaintiff can compel the production of documents from the defendant who violated the competition law. So that's definitely the increased civil damages litigation risk for the companies who has potential issues with the violation of Korean competition law. So since the trade secret is not a legitimate ground, and even if the document has trade secret as a content, then such kind of document can be seen in the court as a in-camera procedure. So this is definitely a procedural improvement for the plaintiff, and it may be higher risk for the defendant. Thank you.
Okay, so I guess it's now time for some Q&A. Okay, question, I guess we're taking this question first from Winston Kiang. And with respect to the page entitled Private Enforcement Injunctive Relief, can you suggest some practical steps for enterprises to comply with unfair trade practices, abusive secure bargaining position, imposing unfairly disadvantageous terms provisions? Since injunctions can be draconian and sometimes more serious than monetary damages, is there a balance of convenience test that the KPC and the law courts will apply for granting injunctive relief? Someone
okay. Yep, this relates to my presentation. Thank you, Winston. First of all, what are the practical tips for companies to comply with the unfair trade practices? This it is so-called the superior bargaining position issue in terms of the bilateral relationship between the inferior party and the superior party. And it is important that this kind of situation may be regulated by the KFTC for violation of Korean competition law. Issue is that the KFTC does not look at the competitive harm aspect in this investigation. They just look at whether the conduct is against our normal norm of justice. So whether it's a unfair means of competition or not. So the criteria can be sometimes very arbitrary and can be inconsistent with its own precedent. But some of the practical tips for companies is that, for example, the contractual terms should be abided by in all aspects. So, for example, the companies may want to terminate the transaction with the other party because, for example, the other party does not perform very efficiently. But in that situation, the procedure for termination should be strictly abided by, and also it is desirable to not extend the agreement rather than terminating during the agreement period, contract period, and also when you terminate the other party, it is important to make the other party understand why they are terminated, or what is the desirable performance they failed to meet. This kind of a discussion is important to make them understand the situation and make them less unhappy about the situation to not run to the KFTC. So most of this unfair trade practice case takes place with the KFTC mostly by the report to the KFTC by these unhappy terminated counterparties. So discouraging them to run to the KFTC is very important. Next question. The balance of convenience test for injunctive relief. It is very good question, but very tough question for us because we have never enforced this injunctive relief case in reality for now. So this is a new realm of the competition law, and probably it's new for the court as well. So we don't know what kind of a test will be applied by the court in the actual injunctive relief case so far. Our concern also is that whether it may be effective from the plaintiff's perspective as well, whether it may be effective compared to the reporting to the KFTC. So most of the concerns by the parties, by the plaintiff, is that it takes too long for the KFTC to complete its investigation. And even if the KFTC completes its investigation, it does not directly rescue their antitrust harm because they have to file separate civil lawsuits under current system. So for this injunctive relief to be effective for the plaintiff, then the plaintiff should get the confidence that the court will decide the case as soon as possible, decide the case earlier in the KFTC's investigation, and it will directly rescue their antitrust harm. Like I said before, in making that kind of a judgment, it may be difficult for the court to get enough information, enough objective information from both parties, and without the necessary assistance from the KFTC. So we will have to see what will happen in the past, in the future. And I'm sorry for not being able to provide a definitive answer for this question.
Thank you, Sanghoon. Understand we have another questioner standing by.
Hi, thank you, panelists. Hi, thanks for a very informative session, and it's certainly helpful to understand all the recent changes from the anti-competition of foreign perspective. I have a question here, and if you don't mind to seek your input. First of all, in view of the recent amendments, what are the key points to note, essentially the do and don'ts when we discuss with our distributor, and also in general across all industry, what proposed changes would you recommend to your clients, to the existing distribution agreement that you have? Thank you.
Daniel, I understand it's the General Regional Counsel for Google Corporation, Singapore office. Hyuna, could you respond to the question?
Okay, Daniel, in a relationship between a supplier and a distributor, as Sanghoon just briefly mentioned, certain types of conduct, for example, imposing any kind of disadvantages without any contractual grounds on the distributor, may be regulated as an unfair trade practices, in particular an abuse of superior bargaining position. This is abuse of superior bargaining position is different from abuse of dominance and is unique in Korea. Furthermore, if the distributor meets the requirements for small and medium-sized business, then a special law called Fair Agency Transaction Act may also apply as a special law to the MRFTA. So the KFTC drafts and announces kind of standard, form standard distribution agreement and post it in its website. Unfortunately, no official English versions are available, but you may try to get some idea about how the KFTC's measures certain agreement is at a fair terms. There is a particular form standard agreement for medical devices industry as well, which I understand is published January this year. That's the last one we saw. You may also can access to such standard distribution agreement on KFTC's website. One particular clause I'd like you to pay attention is a clause that grants a right to request the renewal of contract term up to 4 years in medical devices industry to distributors, including its initial term. So this guaranteed renewed term differs for many different industries. So not the same 4 years apply for all kind of industries. While this standard form agreement is not binding, and KFTC also recommends to use it, but as I mentioned, you may have an idea what kind of fair terms the KFTC is thinking about. So given this high risk of violation and the level of sanctions we just discussed at our webinar today, you may consider following terms contained in this standard form agreement as much as possible as a practical tip for your compliance.
Okay, thank you, Hannah. And Daniel, do you have another question for us?
Thank you, Keewon. I'm mindful of time, but after following the presentation, I have another burning question, and this is the last one, if you don't mind, is that I just want to ask that in the case if competitor were to exchange information to a third party, for instance, like an industry publication or statistics provider, which they are typically interview all the competitors in the market, and then they gather intelligence and publish them. So my question is whether such exchanges will be penalized in view of the recent amendment. Thanks a lot, Keewon. Thank you.
I'll be answering that question since it does relate to my presentation. So by definition, if it's a unilateral acquisition or providing information, that's not a exchange. Exchange requires there be both-way transfer of information. So if it's a unilateral acquisition, then it would not be called as an exchange of information. So and furthermore, data that these third-party industry publications or market researchers they publish are aggregated. It's not with respect to a single particular company. So they generally would not be regarded as a competitively sensitive information. And but that said, if there is an exchange of sensitive information among competitors using these third parties as an intermediary, and if such third party actively contributes to the information exchange among competitors knowing that it will lead to collusion, for example, they exchange price information knowing that they'll receive it and send pricing information to each other using these industry publications or market researchers as the hub, then it may constitute what's called a hub and spoke cartel. And such third party may be punished as a facilitator of a cartel, with the members who contribute information to that cartel being also being punished as a participating in cartel. As I said, these are our, and it's good that you point out, I mentioned this point briefly with respect to Europe. There's always a question of how the information flows, where the information is acquired, what type of information is granted. That's always going to be a question for these types of general enforcement rules. KFTC does actually provide a very specific guidelines and scenarios where they would be sanctioning certain types of activities. And the KFTC is also preparing a draft guidelines on the types of information exchange they'll be prohibited under the amended MRFTA. They actually haven't published it yet, but once they do, we'll have a better understanding of what those specific types of conducts will be once the guidelines are issued, and maybe think about what are then safer types of information exchanges. Again, I think our advice for now is to just remain careful eye over any sort of information that may be competitive instead of just very generic, pricing, quantity, output, so on and so forth. So hopefully this addresses the question you had on information exchange. I don't see any other questions, so that's it for the sessions that we have prepared today. And we just want to thank all of you who joined today, as well as the American Chamber of Commerce. Obviously, the issues that we have covered are, again, very complex, and given the time constraints, we didn't get to cover every single issue in depth, but hopefully today's session was a helpful starting point in putting you on the right path of thinking about how these changes can impact your businesses in Korea. You should also be able to find our information either through our firm's website or on AMCHAM's link on this webinar, and we'll be happy to discuss any specific concerns you may have on this topic. Thank you again for joining today. Bye-bye.
Bye.
Bye.